Welcome to Title VI training for Nebraska Department of Transportation subrecipients or local public agencies. This introductory module is the first of 4 civil rights related training modules that were developed by the Nebraska DOT in July 2022. This first module is on the background, context, and legal overview for Title VI of the Civil Rights Act of 1964 and related statutes and regulations. Module 2 will be on specific Title VI responsibilities of local public agencies or NDOT subrecipients with a review of some example documents. Module 3 is on the topic of limited English proficiency requirements for local public agencies or NDOT subrecipients. And then finally, Module 4 is on transportation-related Americans with Disabilities Act requirements for local public agencies and NDOT subrecipients. Both of these modules also include links to example documents. So let's begin our introduction to Title VI, including its background and some contextual information, as well as its legal foundations. The Civil Rights Act of 1964 emerged as part of the civil rights movement of the 1960s. President Kennedy sought legislation giving all Americans the right to be served in facilities which are open to the public. For example, hotels, restaurants, theaters, retail stores, and similar establishments. He was also interested in preserving a greater protection for the right to vote, as well as school desegregation. So originally in 1963, President Kennedy proposed a bill that was focused very heavily on public accommodation, voting rights, and school desegregation. Civil rights leaders urged a more comprehensive bill, which would prohibit discrimination by private employers, for example. Following President Kennedy's assassination in 1963, President Johnson pushed for rapid passage of the expanded version of the bill. President Johnson said only 5 days following Kennedy's assassination that no memorial, oration, or eulogy could more eloquently honor President Kennedy's memory than the earliest possible passage of the Civil Rights Bill for which he fought so long. President Johnson had served in all elected offices at the federal level, in the House, in the Senate, where he had been the majority leader, as vice president, and now as president. He knew the players in Congress. He knew the legislative levers to pull, and particularly following President Kennedy's assassination, he had the political capital to get this bill passed. And so, after a long filibuster attempt in the U.S. Senate by primarily Southern senators, during which the bill underwent several revisions, the bill passed and was signed into law by President Johnson on July 2, 1964. The Civil Rights Act of 1964 remains one of the most significant and far-reaching legislative achievements in American history. These are the final titles or sections of the Civil Rights Act of 1964. For our training today, we're interested in Title VI, non-discrimination, and federally assisted programs and activities. This is where the underlying statutory authority for most of today's training is found. I've also bolded Title VII of the Act as well, because many people have a general familiarity with equal employment protections. I want to note that these are generally not an aspect of Title VI compliance, as I'll touch on a little more in an upcoming slide. This is the fundamental operative text from Title VI of the Civil Rights Act of 1964. No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Notice that in the language of the Act itself, only race, color, and national origin are the protected classes. Other protected classes emerged over time in additional laws, regulations, and executive orders. We will examine each of these additional protected classes shortly. The U.S. Department of Transportation and the Federal Highway Administration both have regulations which implement Title VI. These are contained in the Code of Federal Regulations. First, we have the U.S. DOT regulation implementing Title VI at 49 CFR 21. These regulations were issued on June 18, 1970. They include a list of specific prohibited discriminatory actions. They require recipients' execution of a Title VI assurance as a condition of receiving federal aid. Federal aid contractors may not discriminate in their selection of subcontractors under this regulation. 49 CFR 21 also includes some rudimentary environmental justice protections. For example, the regulation states that a federal recipient shall not locate or design a highway in such a manner as to require, on the basis of race, color, or national origin, the relocation of any persons. And then finally, the regulation provides for some sanctions in the event of non-compliance. The Federal Highway Administration regulation, which implements Title VI, is found at 23 CFR 200. This was issued on December 10, 1976, and it lays the foundation for many of the specific requirements for state transportation agencies and subrecipients or local public agencies that we'll be looking at in Module 2 of this training. For example, this regulation is where the requirement to provide signed assurances is found. It also requires state transportation agencies to institute corrective actions to address deficiencies found by FHWA within 90 days. It includes specific actions and activities that state transportation agencies and local agencies or subrecipients must take to assure Title VI compliance. And it also requires state transportation agencies to create their own Title VI programs. I'd like to take a few slides to define and elaborate on some terms that will be used during this presentation and that are used in the text of Title VI of the Civil Rights Act of 1964. And so first, let's look at the term person. Now, just a few slides ago, we looked at this fundamental text from Title VI of the Civil Rights Act of 1964. Importantly, the protections in this text are guaranteed to persons in the United States. So this applies to any person present in the United States. U.S. citizenship is not a requirement to enjoy the protections of Title VI. Again, in this foundational Title VI text is the term federal financial assistance. This term does not apply strictly to money, to federal funding, although in most cases, federal money to construct transportation projects is what subrecipients of the NDOT have received. And so in addition to the grant or loan of federal funds, federal financial assistance might also include the grant or donation of federal property, the detail of federal personnel, or the sale or lease of or permission to use federal property or any interest in such property. Title VI literally refers to Title VI of the Civil Rights Act of 1964, as we've looked at. But in Federal Highway Administration and US DOT parlance, Title VI is also a sort of catch-all or umbrella term that refers to the entire program of non-discrimination requirements and authorities pertaining to recipients or subrecipients of federal financial assistance. And so we see here that at 23 CFR 200, that's the Federal Highway Administration implementing regulation, Title VI is defined as the system of requirements developed to implement Title VI of the Civil Rights Act of 1964. References to Title VI requirements and regulations are not limited to only Title VI of the Civil Rights Act. Where appropriate, this term also refers to the civil rights provisions of other federal statutes to the extent that they prohibit discrimination on the grounds of race, color, sex, or national origin in programs receiving federal financial assistance of the type subject to Title VI itself. Now, I've used the term recipient a couple of times already, but the term recipient is defined as any state or any political subdivision, any public or private agency, institution, or organization, or any other entity to whom federal assistance is extended, either directly or through another recipient, for any program. For the purpose of this training, when we use the term recipient, we generally mean the Nebraska DOT. State transportation agencies are the most common primary recipients of federal funding in the FHWA US DOT program. Though technically recipient applies to any entity receiving federal financial assistance, whether they're a primary recipient or they're receiving federal assistance through another agency, the term recipient technically applies to everyone. Now, having said that, it is very common to use the term subrecipient to describe a local agency, for example, who receives federal transportation funding through the NDOT. The term subrecipient is not defined in any regulation, but it is very commonly used in the FHWA US DOT Title VI program to refer to any recipient who receives federal funding through a quote-unquote primary recipient. So again, in general, for the purpose of this training, when I use the term subrecipient, it refers to a local public agency who has received or is receiving federal aid through the NDOT to construct transportation projects, cities, counties, maybe villages, metropolitan planning organizations, and so forth. This definition and the one following are very high-level overviews. There is much to discuss or even debate within these two topics, but these broad definitions will be sufficient for our training today. And so disparate treatment is when similarly situated persons are treated differently because of their membership in a protected class. This is sometimes referred to as intentional discrimination. A violation occurs when evidence shows that an entity adopted a policy because of its adverse effects upon an identifiable group. If a recipient explicitly conditions receipt of benefits or services on a beneficiary's protected class, or directs adverse action to be taken based on membership in a protected class, it is very likely committing a disparate treatment discrimination offense. Disparate treatment can create a private right of action. A private individual generally does have the right to sue to enforce their rights in a disparate treatment circumstance. Disparate impact refers to discrimination that is quote-unquote unintentional. It's generally the result of a policy that appears neutral on its face, but has a discriminatory effect. This is often proven through the use of data that demonstrates a pattern of discriminatory effects to certain protected classes. A recipient or a subrecipient must be prepared to show that the policy in question has a substantial legitimate justification and that no less discriminatory alternatives are available. Disparate impact situations generally do not allow for private lawsuits under Title VI, but federal agencies may impose disparate impact regulations, as the FHWA and US DOT have, which are enforceable under administrative law by those agencies. Individuals can file complaints with the FHWA or the US DOT against recipients or subrecipients, and federal agencies may initiate compliance reviews, and they may find recipients non-compliant, resulting in a potential loss of federal funding. Disparate impacts can be tricky to identify in advance, which is why a recipient should collect demographic data on its program participants or beneficiaries, which is a requirement under the Title VI regulations anyway, and take time to carefully consider the potential effects of its policies and actions. Now we'll move on to looking at supplemental authorities or additional regulations, laws, executive orders, which make up the US DOT or FHWA Title VI program. We'll be touching on each of these individually in the following slides. First is the Uniform Relocation Assistance and Real Property Acquisition Policies Act, or the Uniform Act, as it's commonly called. The purpose of this act is to provide uniform, fair, and equitable treatment to persons whose real property is acquired or who are displaced in connection with federally funded projects. Also, to ensure relocation assistance is provided to displaced persons to lessen the emotional and financial impact of displacement, and to ensure that no individual or family is displaced unless decent, safe, and sanitary housing is available within the displaced person's financial means. Section 504 of the 1973 Rehabilitation Act ensures that no qualified handicapped person shall, solely by reason of his handicap, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity that receives or benefits from federal financial assistance. This applies to recipients of federal financial assistance, and it is still in effect, but Section 504 has largely been superseded by the ADA. Section 504 of the Rehab Act was sort of a prototype for the ADA, which contains many more specific provisions and protections. Section 504 regulations can be found at 49 CFR 27, and we'll look at this law a little more closely in Module 4, which is on the Americans with Disabilities Act and disability protections in general. The 1973 Federal Aid Highway Act was a highway funding bill of the same kind we see today. For example, it established the Highway Safety Improvement Program. But among its funding and programmatic provisions, it also established sex as a protected class in the US DOT FHWA Title VI program. And so no person shall, on the grounds of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal assistance under this title or carried on under this title. I'll note as well that in 2020, this U.S. Supreme Court case Bostock v. Clayton County ruled that sexual orientation and transgender status is now also protected under the definition of sex. The 1975 Age Discrimination Act prohibits discrimination on the basis of age in programs and activities receiving federal financial assistance. Note that this is distinct from the Age Discrimination in Employment Act, which codifies age protections for employees who are age 40 or above. The 1975 Age Discrimination Act applies to all ages, and an employment relationship is not required. I've most often seen this law arise in the context of project planning. The Nebraska DOT identifies, for example, retirement communities when we perform project-level environmental justice analyses. As this law protects all ages, a recipient should beware making policy or construction decisions that impact certain age groups disproportionately. The 1990 Americans with Disabilities Act and the 2008 ADA Amendments Act expanded disability protections dramatically beyond the parameters of Section 504 of the Rehabilitation Act. ADA, for example, applies to all public entities, whether or not they're recipients of federal financial assistance. The 2008 ADA Amendments Act pushed back on some Supreme Court interpretations of certain terms in the ADA, and it codified more specific definitions for some terms and concepts that were in the original law. We'll be discussing the ADA in great depth in Module 4, so this is just a very high-level slide. Executive Order 12898 on Environmental Justice. The full title is Federal Actions to Address Environmental Justice in Minority Populations and Low-Income Populations. This is an executive order. It's a presidential mandate to address equity and fairness toward low-income and minority populations. The authority for this non-discrimination executive order is rooted in Title VI of the Civil Rights Act of 1964. There is no law or regulation on environmental justice, but FHWA guidance describes a process of project-level analysis, which includes collection of demographic data, analysis of potential adverse project effects to minority or low-income populations, and then also identification of mitigation activities. Executive Order 13166 on limited English proficiency is a presidential directive to federal agencies and recipients to ensure that people who are limited English speaking have meaningful access to services. The full title of the executive order is Improving Access to Services by Persons with Limited English Proficiency. The authority for this arises out of Title VI of the Civil Rights Act of 1964, and in particular, LEP is considered an aspect of national origin protections. An LEP person is one with a limited ability to read, write, speak, or understand English. Module 3 on limited English proficiency will cover this topic in depth. The 1987 Civil Rights Restoration Act was a congressional reaction to a Supreme Court case, Grove City College v. Bell. The act restored the intent of Title VI to require recipients of federal financial assistance to ensure civil rights protections in the delivery of all their programs, services, and activities. Grove City College had argued that because they were receiving federal financial assistance only in their financial aid department, that other departments of the college should not be held to the federal non-discrimination regulations. And this U.S. Supreme Court agreed with them. They ruled that Title VI covered only the programs that are directly receiving federal funds, and other programs, for example, the athletic department, that did not receive federal funds were free to discriminate on the basis of gender in this case. Institutions could continue to receive federal funding even if the non-federally funded programs within those institutions were discriminating on the basis of sex, race, age, national origin, disability. This is what the Supreme Court ruled. The Congress disagreed, and the 1987 Civil Rights Restoration Act overturned the Grove City decision by saying that, again, it was Title IX in this case, applies to all operations of a college receiving federal funds, whether those funds are directed to that program or not. For educational institutions, Congress made clear that the 1987 Civil Rights Restoration Act extended the non-discrimination protections to all operations of the institution. For governmental entities, Congress limited it to all the operations of a department within that governmental entity. So, for example, if a local agency or a federal aid subrecipient only receives federal funding for, say, a transit program, but the transit program is located in the Streets and Utilities Department, then the entire Streets and Utilities Department would be subject to the non-discrimination regulations, but not necessarily the other departments and programs of the local agency unless they too received federal funding. Now, the exception is if a local agency receives federal financial assistance in one department and then distributes it from that department to other internal departments, then those other departments would be hooked in and covered by the Title VI non-discrimination regulations, even if they are not recipients themselves. This is a good place to distinguish Title VI of the Civil Rights Act of 1964 from Title VII. And this is just a very high-level view of Title VII, only to distinguish it from Title VI. Title VII applies to employment-related circumstances, very complex area of employment law, but again, not within the scope of our training today. And so we're just going to take a very quick look at the differences. Title VI, as we've seen, is concerned with participation, benefits, services, and discrimination arising from the implementation of programs or activities involving federal financial assistance. It applies to all persons who might be beneficiaries of that federal financial assistance. Title VII concerns employment and employment-related non-discrimination practices. It protects employees from various workplace harms, hiring, firing, discipline, promotions, etc., that are motivated by the employee's membership in a protected class. Among other differences, Title VII includes religion as a protected basis, which Title VI does not. Now, as with everything, there are exceptions, and there is one or two possible scenarios, very rare, where Title VI may apply to an employment situation. Employment may be within the scope of Title VI protections when the primary purpose of federal financial assistance is to provide employment. And an example of this that I've seen is a program like the Welfare to Work program, whereby assistance is provided by the federal government to allow people on welfare to enter into gainful employment. The other scenario is when discrimination in employment leads to discrimination in public services or benefits. And so this slide is just a summation of all the protected classes under the Title VI umbrella: race, color, national origin from the text of Title VI itself, persons displaced or relocated from the Uniform Act, disability from the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, sex from the 1973 Highway Bill, age from the 1975 Age Discrimination Act, and then low-income populations from Executive Order 12898 on environmental justice. Low-income populations applies only within environmental justice. And then finally, limited English proficiency, which I've included in parentheses as kind of a subset of national origin protections. So after all this, we can finally arrive at a sort of working definition of discrimination for the purposes of the US DOT FHWA Title VI program. The act or omission, whether intentional or unintentional, through which a person in the United States, because of race, color, national origin, sex, age, or disability, has been subjected to unequal treatment or a disparate impact under any program or activity receiving federal assistance from the Federal Highway Administration under Title 23 USC. This definition is a modified version of one found at 23 CFR 200.5. It's been modified to include additional protected classes and to include concepts such as disparate impact. To say it more plainly, discrimination is an illegal act which results in disparate treatment or impact because of one's membership in a legally protected class or group. Specific discriminatory actions which are prohibited by the US DOT or the FHWA implementing regulations are included on the following slides. A recipient may not directly or through contractual or other arrangements on the grounds of membership in any protected class within the scope of the US DOT or FHWA Title VI program, deny a person any service, financial aid, or other benefit provided under the program. A recipient may not provide any service, financial aid, or other benefit to a person which is different or is provided in a different manner from that provided to others under the program. A recipient may not subject a person to segregation or separate treatment in any matter related to his receipt of any service, financial aid, or other benefit under the program. A recipient may not restrict a person in any way in the enjoyment of any advantage or privilege enjoyed by others receiving any service, financial aid, or other benefit under the program. A recipient may not treat a person differently from others in determining whether he satisfies any admission, enrollment, quota, eligibility, membership, or other requirement or condition which persons must meet in order to be provided any service, financial aid, or other benefit provided under the program. A recipient may not deny a person an opportunity to participate in a program through the provision of services, or afford him an opportunity to do so which is different from that afforded to others under the program. And then finally, a recipient may not deny a person the opportunity to participate as a member of a planning, advisory, or similar body, which is an integral part of the program. On the next slides are a few aspirations of the Title VI program, and you may notice that some of these look like the specific prohibited actions just in reverse. And so it's an aspiration of the Title VI program to prohibit recipients from denying an individual any service, financial aid, or other benefit because of their membership in a protected class. It's an aspiration to prohibit recipients from providing services or benefits that are different or inferior to those provided to others, again, based on someone's membership in a protected class. It's an aspiration of the Title VI program to prohibit segregation or separate treatment in any manner related to receiving program services or benefits. The Title VI program aspires to prohibit recipients from requiring different standards or conditions as prerequisites for serving individuals. It aspires to prohibit discriminatory activity in facilities built in whole or part with federal funds. And it aspires to require information and services be provided in languages other than English when significant numbers of beneficiaries are of limited English speaking ability. It's an aspiration of the Title VI program to require recipients to notify the eligible population about applicable programs. It's also an aspiration to prohibit locating facilities in a way that would limit or impede access to a federally funded service or benefit. And finally, the program aspires to require assurance of non-discrimination in the purchase of services. If you have any questions on this first module, feel free to contact me at the information shown here or the Nebraska DOT Civil Rights Office. Their contact information is located on the first slide of this first module.